This is your jury charge reading for Performance Challenge Week number 13. Good morning, ladies and gentlemen of the jury, period. I thank you all for being here on time and for your patience, period. I have a few little instructions, period. I am going to try to cut through them as quickly as I can so that we can give you some evidence before the lunch hour, period, paragraph. The lawyers may choose to give opening statements in this case, period. These statements are not evidence, period. They are made to help you understand the nature of the case and the evidence, period, paragraph. The law states that you will render a verdict only on the evidence submitted to you under the rules of law, period. The evidence you may consider will consist of the testimony of witnesses either in person or through written transcripts of their testimony called depositions, period. Evidence will also be presented in the form of physical objects or documents called exhibits, period, paragraph. Do not go to any of the locations referred to by any of the witnesses in this case or perform any type of investigation of facts in this case, period. You will receive all of the evidence you will need to decide this case here in this courtroom, period. So after a while, we are going to take a little lunch break, period. At that time, you cannot go to your car and try to go to investigate anything about this case, period. You simply cannot do this, period, paragraph. Likewise, do not go to the courthouse and look up any records in order to get information over and above what is given to you during the trial, this trial, period. You must not watch anything about this case on TV or read anything about it in the newspaper, period, paragraph. Please listen carefully to the testimony, period. No testimony will be read back to you unless you disagree about a statement made by a witness during the trial, period. Now, I want to explain that last part to you a little bit, period. Suppose you hear a witness saying, quote, well, I stopped this person because they were speeding, period. They were going 55 miles an hour, period, close quote. You hear that it was 65 miles an hour, period. So you are in the back and you are trying to find out whether it was 55 or 65 miles per hour, period. That is easy to understand that perhaps you just heard it wrong and you don't know what the witness actually did say, period, paragraph. You can clear that up by asking me what the witness actually did say, period. I will then instruct the court reporter to look up the testimony, comma, find the place where the person testified, comma, and then we will call you back out and read the questions and the answers to you until you get the information you need, period, paragraph. It is rarely used, comma, but it has been used on occasion to clear up some disputes within the jury, period. One time I had a jury ask me for all of the testimony of a particular witness, period. That is just not going to happen, period. We are not going to read back all the testimony, comma. So it is important that you listen very carefully, period, paragraph. During the trial, comma, the attorneys may make objections, period. This is a necessary procedure during the trial, period. When an objection is made, comma, I must rule on it, period. There may be times when I must send you to the jury room to allow the parties to argue before me in this courtroom, period, paragraph. You must not concern yourself with the objections or my rulings upon them, period. You must not consider evidence or exhibits to which an objection was sustained, comma, or that I instruct you to disregard, period. Some evidence or exhibits may be introduced by a very limited purpose, period. If that occurs, comma, I will instruct you to consider this evidence only for a limited purpose, and you must do so under your oath, period, paragraph. Each of you must determine the facts as you see them, period. To do so, comma, you must evaluate the credibility of each witness and decide the weight and value to be given to their testimony, period, paragraph. In considering the weight of the testimony of a witness, comma, you may consider the person's appearance, comma, attitude and behavior, semicolon, the person's interest in the outcome of the case, semicolon, his or her relationship to the defendant, comma, or with the state of Texas, semicolon, the inclination of the witness to tell the truth, semicolon, the probability or improbability of the statements that a witness makes, semicolon, the reasonable inferences from those statements, semicolon, and all other factors you feel will help you in giving the testimony of that witness the degree of credibility you feel it deserves, period, paragraph. The trial will go as follows, colon, the state may make an opening statement, period. The defense attorney may do so as well, or may make his statement at a later time, period. The state will then offer evidence through witnesses who will be called to the stand, period. The defense attorney then has the opportunity to cross-examine each witness as he so desires, period, paragraph. When the state has completed its case, comma, the defense attorney may or may not present his evidence, period, paragraph. Please remember that the defendant is never required to prove his innocence, period. This presumption of innocence stays with the defendant until the time that it is overcome by evidence that supports his guilt beyond a reasonable doubt, period, paragraph. The defense attorney is finished when the defense attorney is finished presenting its case, comma, the state may put on rebuttal witnesses, comma, and then the defense may then do the same, period. At the end of the presentation of all evidence, comma, I will read to you the court's charge, comma, and each side will then present closing arguments, period, paragraph. After the closing arguments are completed, comma, you will then be permitted to go to the jury room to deliberate this case, period. It is only at this time that you are permitted to discuss this case in any way, period, paragraph. If you have any questions at all, comma, you may knock on the jury room door and the bailiff, comma, who has you in his charge, comma, will come to the door at that time, comma. You may put your question in writing and hand it to the bailiff, period. He will then bring your question to me, comma, and I will answer that question, comma, if I can do so, period, paragraph. Your verdict must be unanimous, period. When you have reached your verdict, comma, please inform the bailiff, comma, and you will then be returned to open court to give us that verdict, period, paragraph.